Before starting, first I would like to thank the Carriage and Maritime Law Association and also the Inter-University Center for organizing this conference and providing us a platform that we can share our results without any concern. So instead of connecting by video link, actually, I would prefer to be in Dubrovnik and attend the conference in person. And when the professor Igor sent me the program, I checked and I saw a couple of familiar names. And actually it will be great to meet them again and also to meet new academics in Dubrovnik. However, the second wave of the COVID-19 unfortunately makes participating this conference impossible for me, like many of you. So I hope we can find a chance to meet in person in other conferences. As you see that on the screen, I determined the today presentation title as Autonomous Ship, Carriage of Goods by Sea and Legal Aspects. So we all know that the form of the ship has been changed a lot from the beginning, and in spite of all these developments, evolvements, and the progression, there is just one thing remain constant, and it was the crew on the board of the ship. But the crew have always been there. They are responsible for navigation of the ship, safety of the cargo, and other operational things. But however, recent technological developments and also the developments in the automation system now allow us to build the autonomous ships and then use them in the carriage of goods. So considering the economic advantages and also the prospects of better navigational safety, it seems that these type of ships will be used in the very near future. The maritime industry seems excited about this, but they also have some concerns whether the current legal regime will be applicable to these type of ships or not. And today, then, I decided to look to carriage of goods by sea aspect of the what will be happen when we start to use autonomous ships while carrying the cargo. In this, due to the time limit, of course, I will not be considered all these issues, but I just decided to focus on only the three aspects of charter parties. And there are three issues that I want to mention today. The first one is that the ship owns obligation to provide a seaworthy vessel. And the second one is the charter's obligation to order the ship only safe ports. And the third one is liability for loading and discharging operations. And lastly, if we have some time left, I want to mention the other two problems very briefly. So as far as I know, this conference is not just for the expert, but also students who are interested in the maritime law. And since I will focus on the charter party today, I thought it will be better to start with the charter party definition, what it is. So the charter party is defined by the Professor Wilson in his book, saying that where the ship owner agrees to make available the entire capacity of his vessel for either a particular voyage or a specific period of time, the arrangement normally takes the form of a charter party. I choose this definition because this is the most preferred one by the academics. So actually, if the ship owner is making his vessel available just for a particular voyage, like let's say from Hamburg to Istanbul, we are saying that this is a voyage charter. On the other hand, if the ship owner makes his vessel available for a particular period of time, let's say the 5 months, this becomes a form of a time charter. So I believe that one of the most problematic things after the usage of the autonomous ships for carriage of goods by sea, this will be the ship owner's obligation to provide a seaworthy vessel. So when we check the charter parties, we are seeing that most charter parties expressly impose an obligation on the ship provide a seaworthy ship at the time of delivery of it. So clause 2 of, for example, the clause 2 of NIP 2015 is a good example for it. So this clause is saying that the vessel on delivery shall be seaworthy and in every way fit to be employed for the intended service. So for another examples, for example, you can check the line of the NIP 21 to 24 of NIP 46, clause 2 of NIP 93, clause 1 of Maritime. All these are an example of seaworthiness obligation. But there is one thing clear, that even if there is no express seaworthiness obligation in our charter party, they are saying that this will be implied by law. So seaworthiness obligation is always be there, and there is no There's no dispute about that. But what is a seaworthiness? And this is a well-settled definition. It is made in McFadden and Blue Star Line case. And they are saying that a vessel must have degree of fitness which an ordinary, a vessel must have that degree of fitness which an ordinary careful and prudent owner would require his vessel to have at the commencement of her voyage, having regard to all the probable circumstances of it. Would a prudent owner have required that? It means here the defect should be made good before sending his ship to sea, had he known of it. If his answer is no, if he would, then the ship was not seaworthy. So this is how we are coming to the conclusion. So while the seaworthiness evaluation is made, we are actually checking the condition of the ship, its crew, equipment. We are checking we are focusing all these criteria. What we need to do is just check this and decide whether these are fit enough to withhold foreseeable perils that can be encountered during the charter service. In addition to this, it should also be checked whether the ship is to be fit for the contemplated service. So in other words, whether that ship is cargo worthy or not. So seaworthiness in a general sense actually cover the cargo worthiness too. Yes. So there's the seaworthiness obligation is already well settled under the many jurisdiction. But what will happen when it comes to the autonomous ships? There's of course no dispute that the obligation will still continue when we start to use the autonomous ships. But I think it will be a problem because of the fact that this ship contains two different parts. So we all knowing that the traditional ships are just one single item, and they are containing the whole machinery, equipment, and the control center that enables the member of the crew decide to do what to do and what not to do. But when it comes to autonomous ships, we know that there will be not one single item, but it will be two parts. And one of them will be the sea module, and the other one will be the land module. And the land module in academia usually, generally, and also in the sector, generally referred as a shore control center. So the whole, the body of the vessel still be on the sea, but control center is on the land. And actually this is not compulsory, although in many articles it says that it will be located on the land. There is no such a thing. The control center can be in everywhere, even in a particular platform on the sea. So then what will happen? I think because of these two structural construction of this ship, the question springs to mind will be this: while evaluating the fulfillment of the requirement of seaworthiness in a particular case, will attention be given to two parts, or will we focus only the sea part? So actually, some of you might say that the control centers will be on the land, so the seaworthiness term, even in terms of the term seaworthiness, doesn't fit to something on the land. So actually, this has some logic, but as I told you, there is no requirement that the control centers will be on the land, because it might also be somewhere on the sea. So actually, I believe that the answer of these questions depends on whether can be accepted. Depends on whether that control center can be accepted as essential components of the ship. So this should be the question that we need to ask. I don't know the other jurisdiction too much, but under the Turkish law, while we are determining whether one thing is the essential components of the other things, we are focusing on whether those parts can be separated from each other without causing a damage or not. For example, the walls of the house are accepted as an essential component of the house, because if you remove the walls, then that house will collapse. So when we focus on this test and check the control center, whether it's essential components of or not, we are saying that, okay, these are already separate, so that doesn't look like an essential component of each other. This is right, but now that we've started to change, and there's a modern view here, and they are saying that the attention should be given to the degree of operational and functional connection between them. If there is a degree of operational and functional connection is so close, then we can say that there are essential components of each other. So because of this, for example, I thought that imagine imagine that, just example I create here. So when we think about it in terms of this issue, without one part, I think the other cannot continue activities. We imagine that the C part of the autonomous ship is properly working, but no connection is provided between the ship and the control center due to the technical problem in the center. So in such a case, the ship cannot go anywhere if it is, especially it's a remote control ships. The situation might be a bit different if it's a fully autonomous ships. But in that case, again, that in some situation that the people in the remote control center need to interpret particular things. So if there's no connection because of the technical problems, we are seeing that the ship may not do anything. That's why I believe that there is there's enough functional connection between an operational connection between them. And that's why we need to reach the conclusion that there are essential components of each other. That's why that while we are evaluating the seaworthiness, we should focus on the both parts. Let's say that I create an again example here. If the sea part is capable of proceeding the voyage technically and safely, but there is an insufficiency of control center staffs then that are engaged in the ship, then we can say that that ship is unseaworthy. If you remember the test I have just given 2 slides before, is saying that would a prudent owner have required that the defect should be made good before sending his ship to sea had he known of it? If he would, the ship was not seaworthy. So if the ship owners know that the person in the control center is not capable of using of that ship, he definitely not sending that ship to the sea because he doesn't want to put his ship under risk. That's why that in the situation like in this example, that the ship should be accepted unseaworthy. And the most important, while we are making the seaworthiness analysis, we should not only focus on the ship, and also we should evaluate the situation in the control center. Apart from this, in terms of the seaworthiness, other things that I want to say, the content of seaworthiness should be reconsidered, because now while we are evaluating the seaworthiness of the traditional ship, we are focusing on the condition of the whole machinery, equipment, and the qualification and certification of the crews. But when it comes to the autonomous ship, we will of course again consider these things that I said above, but in addition to this, we also need to check the computer programming equipments, hardware and software of the vessel, cyber risk management system, connection, qualification of the control center's personnel for being able to use the autonomous ship. All these should be in consideration. So the extent will be a bit wider than the current seaworthiness analysis. And the third issue that I want to mention about the seaworthiness, some of you may say that, okay, we will check the computer programming equipments, and this is the responsibility of the carrier, ship owner carrier. But you can say how he knows that his vessel is capable of doing this. I mean, this is something that's requiring expertise, because not every ship owner can understand the hardware and software system. So in those situations, of course, that the most carrier usually, I think, we rely on what the programmers are saying or what the subcontractors are saying. So, but there's something I think we shouldn't forget. We shouldn't forgotten here. In Hague and Hague-Wisby rules, Article 3.1 is saying that imposing an obligation to the carrier should show a due diligence to make the ship seaworthy. So. Because of this provision, I believe that, for example, the carrier cannot say that, okay, I make a proper arrangement with subcontractor to arrange all those computer programming equipments, and I found the best one. So if something happened because of the computer programming equipment system, I'm not responsible. So the ship owner or the carrier, I mean, cannot be able to say this, because that he cannot escape from the liability saying this, because making a contract with the proper contract with the subcontractors is not enough to prove that the carrier showed the due diligence. So this is, I think, one of the important points. And the other issue, the other things that we need to consider after the usage of the autonomous ships for carriage of goods by sea is the charter's obligations or the ship only safe ports. Actually, this obligation of the charter is discussed recently many times because of the COVID-19, because the charter wants to send their ship to the ports which are which there are people in the COVID-19, and then the owner doesn't want to go to that port and say that the port is unsafe. So that's why that this obligation is discussed many times and recently. And also, I think we need to check this obligation in terms of autonomous ship. So in time, when we check the in-time charters, we are seeing that it is common to see an express limitation that the charter can use the vessel only between safe ports and safe berths. So clause 1B of the NIP 2015 is a good example for this kind of warranty. So it's saying that the vessel shall be employing such lawful trades between safe ports and safe places within the following trading limits as the charters shall direct. For another example, clause 2 of Maritime and also clause 4C of shell time form can be shown. So in most charter, we are seeing that this is expressly stated, but under the English law, they're also saying that even if there is no such a provision, then it should be implied by law if it is necessary to give a business efficiency to the contract. But what is a safety? When the port is accepted safe, so this is settled the Eastern City case. They say that a port will not be safe unless in the relevant period of time, the particular ship can reach it, use it, and return from it without, in the absence of subabnormal occurrence, being exposed to danger which cannot be avoided by good navigation and seamanship. Actually, this is a very well settled definition, and actually there is not too much dispute about it. So when it comes to autonomous ship, how will we evaluate the safety? I think safe port warranty will definitely continue to exist, but what the safety again will not be the same. Why? Because the mooring and also the navigation of these type of ships are quite different than the normal ships. So just yes. So for example, the mooring facilities of, let's say, the Istanbul ports can be fit for the traditional ship, but the same facilities might not be enough for the autonomous ships. For example, in order that the unmanned ships are safely berthed, particular hardware or sensors might be required at the port of the vessel. In such a case, if if this kind of hardware and sensors are absent in the port, we will say that that port is unsafe for that ship, because that ship cannot properly approach to that port. Even if it tries, then it will not be managed. I mean, the seamanship will not work here, because there should be a sensors and to give an idea to the people in the control centers. So that's why I believe that criteria which are used to determine whether the porting question is safe for that autonomous ships or not should be reviewed and also reconsidered. And until the introduction of this new criteria, as we know that charter party is a freedom of contract, so instead of just saying that the charter can use the ship only between the safe ports, maybe the parties of the contract should add specific terms when that port will be safe for that autonomous ship. So this might reduce the number of disputes that will arise within time. So and the third issue is the liability for the loading and the discharging. So we all know that currently cargo operations on the port are usually handled by the humans, and also, of course, with their help of some machines. But we all know that autonomous ship designed to go from one place to another without any human interaction on the voyage. But it's also expected that some of the autonomous vessels are designed to feature of handling, loading, and discharging operations automatically. And one of the good example for it is the Yara Birkeland, and which is the world's first fully electronic and also the autonomous container ship. It hasn't launched yet, but it is designed to handle the loading and discharging operations on her own, so without any human interaction, and she's doing that one is doing everything on her own. So if this is, if all the cargo vessels are started to do this, then this will create a problem in charter context, because that under the current regime, when we check it, we are seeing that liability for the loading and the discharging, the risk of this usually imposed to the charterer. But we know that if this one is done by the ship, then I think the ship owner should go into the picture, and then those terms should be reviewed, and then those kind of risks should be imposed to the ship owner, and should design in that way. And so these are actually the main issues that I want to mention. But I also want to say something about these two issues. I haven't completed my research about these two, but I just want to give idea the other possible problems. So the other one is a limitation of the ship owner's liability. We all know that some form of limitation has been adopted by many countries on the fact, and a ship owner should not be found himself in a position of being liable for more than the value of his trading asset, in other words, his ship. So limit of liability is determined by referring to the national value based on the weight on the ship. So the question that springs to my mind here at this point, that while calculating the limitation of the ship owner's liability, should we count the weight of the control center too? So because most of the things will be removed to the control center, and the weight of the autonomous ship will be lessened. So I think this it should be think about it. Maybe it seems not so possible, but I think this is one of the questions that should be answered. At least this is what I am thinking. And the third issue that I want to say, the second issue, the other problems that I want to mention, is also the application of provision related to the exclusion of liability. For example, Article 4, Section 2 of Hay Rules contain a long list of exceptions. So this clause is saying that neither the carrier nor the ship shall be responsible for loss or damage arising or resulting from act, neglect, or default of the master, fires, perils, dangers, and accidents of the sea, and act of God. So this list actually is a very long list, but I just put here the 4 of them. So here the question is, okay, then if something happened for traditional ships, and the carrier can rely on this exception. But my question here, if one of these events happen on the control center, can the carrier still rely on those provisions and say that, okay, I'm not responsible? Let's think about the fire, for example. If the fire occurs in the control, if the fire occurs in the control center without any fault or the privity of the carrier, then can we say that carrier will not be responsible for the loss arising from this event? So this is the other things that comes to mind. But as I already told you, I haven't completed my research about this. But if you have any idea and share with me during the discussion parts, I would be grateful to you. So this is actually the end of my presentation. Thank you for listening.